Hello, everyone. I'm Dean Christofferson, and I'm a member of the CCCBA Board of Directors. On behalf of the Contra Costa County Bar Association, I'd like to welcome you to Day 2 of the 27th Annual MCLE Spectacular. We hope you enjoyed yesterday's programs. This morning's session, our parent-child property transfers done under Prop 19, is presented by the CCCBA Real Estate, Tax, and East County sections. Before we get started, a couple of quick reminders. Our event and program sponsors are a very important part of our CCCBA community. They make it possible for us to provide events like this. Please support us by supporting them. Please take some time during this event to visit the virtual sponsor booths on the Spectacular's website. Next, for assistance with any technical difficulties, head to the FAQs tab on the event's main page. And don't forget, while this program is pre-recorded, the speakers are available live in the chat to answer your questions during the presentation. They will also be available in the live Q&A immediately following the presentation. At this time, I'd like to pass the program over to Allison Wapshall, the president of the CCCBA's Real Estate section, who will introduce our speakers.
All right, thank you very much, Dean. As you mentioned, my name is Allison Wapshall, and I'm the acting president of the Real Estate section of the Contra Costa County Bar Association. Thank you so much for joining us today for our MCLE Spectacular program. As Dean mentioned, this program is co-sponsored with Real Estate, Tax, and the East County section, and it is called Our Parent-Child Property Transfers Done under Prop 19. I'd like to tell you a little bit about the program. Prop 19 dealt a massive blow to parent-child property transfers. Families who intended to transfer their family homes to their children are now faced with substantial increases in property taxes upon transfer. Clients, attorneys, and planners now all face the question of, what can we do now? Our panelists have some answers. In addition to explaining what Prop 19 did, our panelists will discuss and outline a strategy that families may employ to transfer property to their children while mitigating or eliminating the property tax reassessment. We will also provide an update as to the movement to change Prop 19. And with that, I'd like to tell you a little bit about our distinguished speakers. First, Ryan Lockhart. He is a partner at McKenna Brink Signorati LLP. Ryan's primary area of practice is helping families and individuals with tax and estate planning concerns. Through careful planning and thorough care of the dynamics involved, Ryan has successfully helped his clients navigate complex tax issues to achieve the desired results. Ryan's an expert in helping families transition wealth and family businesses to younger generations in order to preserve the family wealth legacy, but also keep family harmony intact to achieve family success. Ryan also helps individuals and businesses navigate tax traps, specifically in the areas of income tax, corporate tax, and property tax. As part of the client's advisory team, Ryan helps the team analyze, plan, and execute for the client's benefit. Our second speaker is Marie Quashnock. After 30 years in private practice, Marie has developed extensive experience representing individuals, startups, businesses, and public entities across a multitude of industries. In her transactional experience, Marie has advised real estate clients on a wide range of transactions, including sales contracts, lease arrangements, and debt and equity financing. Marie also possesses a broad civil litigation experience in a variety of areas, focusing primarily on real estate and business litigation. And Marie was named a super lawyer by Northern California Super Lawyer magazine in 2019, 2010, and 2020. And Marie is also a former section leader of the real estate section and a current section leader for the East County section. And she has been a partner at Alvis, Quashnock, and Associates in Brentwood since March of 2013. So thank you again for joining us. And I'd like to turn it over now to Marie to get us started on our program.
Thank you, everybody. So I wanted to first give you a bit of an introduction on Prop 19, which marked a landmark change to Prop 13, which was the 1978 law that aims to limit property taxes. Prop 19 contains two relevant changes in California property tax assessments that may impact your estate planning. First, Prop 19 expands the ability of seniors, disabled persons, and people affected by wildfires to transfer their tax base to a replacement property. Second, Prop 19 limits the availability of the parent-child exclusion for purposes of real estate tax reassessments. During this presentation, we will review California's existing property tax law and the 2 reassessment exemptions, which changed in 2021 under Prop 19. We'll also discuss new calculation for taxable value for family homes upon certain transfers and provide some tax and estate planning strategies in view of Prop 19's new rules. We're also going to give some thoughts on what the future might hold for Prop 19. So first, I want to talk a little bit about Prop 13, give you a little background. It was passed in 1978, officially named the People's Initiative to Limit Property Taxation. It's commonly referred to as Prop 13. This proposition amended the California Constitution and established several fundamental principles for real property taxation in this state. Among other things, it sets assessed valuations of real property back to the 1975-76 taxable base year amount. It caps annual increases in property taxes at 2%. It prohibits reassessment of the base year value except following a change of ownership or a completion of new construction. It also limits the maximum county-wide rate property taxes to 1% of the market value of the property, which is also referred to as full value or cash value. Proposition 8 also was passed, which limits the assessable value of real property to its fair market value on the lien date, which may be lower than the adjusted base year value due to damage, destruction, property removal, or other factors that might cause a decline in the value of the property. During periods where there's a decline in real estate values, assessors have unilaterally reduced the value of properties within certain areas to reflect general reduction in value of real property. However, generally taxpayers must request a reduction in the assessed value of their properties to fair market value with the Prop 8 application or through an assessment appeal. In 1986 and 1988, respectively, Propositions 60 and 90 amended Section 2 of the California Constitution to allow a person who is over age 55 to sell his or her principal place of residence and transfer its base year value to a replacement dwelling of equal or lesser value that is purchased or a newly constructed within 2 years of the sale. Proposition 110 extended the exemption to severely or permanently disabled persons of any age. These propositions were implemented by Revenue and Tax Code Section 69.5. Proposition 60 allowed for transfers of base year value within the same county, while as Proposition 90 allowed for transfers of base year value from one county to another in California if the county had authorized such a transfer. Prior to 2021, there were 10 counties in California that allowed for intercounty base year value transfer and only 2 in Northern California, San Mateo and Santa Clara. Eligible homeowners could claim the exemption only once and could only do so if the value of their new home was less than or equal to the value of their old home. Also, there was a 2-year time limit between the sale of the original property and the purchase of the replacement property. Under Prop 19, which took effect April 1st of 2020, the class of homeowners who were able to transfer their taxable value was expanded to include victims of wildfires and other natural disasters, regardless of their age or disability status. Now eligible homeowners include persons 55 or older, persons who have severe disabilities, or persons who have lost their home in a natural disaster. The new law also removes the restriction that the replacement home must be in the same county as the old home. Eligible homeowners may now transfer their tax bases anywhere within the state and to a property of greater value, whereas previously homeowners were limited to transfers within certain counties, and the home had to be the same or lesser market value. So the new law now allows homeowners to buy a replacement home that is worth more than their old home, provided, however, that the increase in value is added to the transferred taxable value of the old home. They will be able to blend their taxable value of their old home with the value of the new, more expensive home. Finally, Prop 19 increases the number of times that certain people may transfer their tax assessments. An eligible homeowner may transfer their tax assessment up to 3 times. A tax exemption form must be filed in the county where the replacement property is located in order to claim the exemption. Now turning to California's parent-child transfer exemption, under the prior law, a parent could transfer his or her California principal residence regardless of how the child uses the residence, and also could transfer other California real property up to $1 million of assessed value to his or her children without triggering a property tax reassessment. The exemption applied whether the transfer occurs by gift or sale during lifetime or at death or outright or through a trust. Thus, transferring a parent's home to one or more children was permissible without triggering reassessment. And the child or children could use it as a vacation home, as a rental property, or to live in. Additionally, any secondary properties such as a vacation home, rental property, or commercial property could be transferred with up to $1 million of assessed value being exempt from the increase in property taxes, regardless of its use by the children. The exemption applied not only for a transfer from parent to child, but also transfer from child to parent, but this is much less common. In 1996, Prop 193 expanded the parent-child exclusion to include grandparent-grandchild exclusion for transfers from grandparent to grandchild where the intervening child/parent has died. Moving now to Prop 19, beginning on February 16th, Prop 19 changed existing law by requiring that the child or children use the residence as their own principal residence or it will be reassessed. Furthermore, even if the principal residence requirement is satisfied by both the parent and child, the exclusion is no longer an unlimited one, but rather it excludes up to an additional $1 million worth of value. Also, the $1 million of additional other property under the old law was eliminated entirely. So if a child chooses to keep the parent's residence as a second home, vacation home, or rental property, there is no $1 million exclusion, and the residence will be reassessed to fair market value at the time of the transfer. A tax exemption form must be filed in order to claim an exemption. Now I'm going to turn to some Board of Equalization interpretational questions and answers that were published initially when Prop 19 had just passed. So one of the questions is, must both the sale of the primary residence and the purchase of a replacement primary residence be completed on or after April 1st, 2021? The answer is no. The operative requirement is that the transfer of the base value must be on or after April 1 of 2021. So not the purchase or sale of either the original or the replacement property. The law makes it clear that if the transfer of the base year value from a primary residence to a replacement primary residence occurs on or after April 1st, then the provisions of Prop 19 will apply. Thus, the event that must occur on or after April 1st, 2021 is the transfer of the base year value. It is not the date of sale of the primary residence or the date of purchase of the replacement primary residence that must occur on or after April 1st, although they are related. What constitutes the date of actual transfer is not specified in Prop 19. However, we believe the transfer should be processed as of the date, as of the later of the date of sale of the primary residence or the date of purchase of the new, the replacement residence, whichever applies, regardless of when the application for transfer was actually provided. Next question. Must the claimant be severely disabled or severely and permanently disabled under Prop 19? Prop 19 requires that the claimant be severely disabled, not severely and permanently. So that's a change from the prior law, which required both severely and permanently disabled persons in order to qualify for the exemption. So it does appear that under the Board of Equalization's view, severely disabled is more broad, and it's not limited to just physical disability. Question 3, on what date is the value of the original and replacement primary residences determined for purposes of calculating the transferable taxable value? The value of the original and replacement primary residences are determined for purposes of calculating transferable taxable value as of the date of sale or the date of purchase or completion of new construction. So while taxable value is defined in subdivision E10 of section 2.1 of the Revenue Tax Code, value is undefined. So for purposes of Prop 13, full cash value is defined in the Revenue and Tax Code as the fair market value of the property as of the date on which a purchase or change in ownership occurs, or the date on which new construction is completed. Therefore, the determination of fair market value of the original primary residence for purposes of calculating the transferable taxable value must be as of the date of the sale of the original property, because the date of sale is the date of change of ownership in the Revenue and Tax Code. Similarly, the date on which the full cash value of the replacement property must be determined as of the date of purchase or the date of completion of the new construction of that replacement property. Question 4, how many times may a spouse transfer an original primary residence pursuant to Prop 19? Answer, each spouse may transfer a base year value up to 3 times. Once again, the Revenue Tax Code provides that for purposes of this section, any person over the age of 55 years, that includes a married couple, so long as one member of which is over the age of 55. This provision has been interpreted to treat spouses as a single claimant if the spouse is already a record owner of the replacement dwelling. Section 2.1 has no specific requirement or limitation as regards to base year value transfer claims from spouses. The Board of Equalization believes that each spouse can transfer base year values pursuant to this section a maximum of 3 times each. And further, they are of the opinion that a transfer completed pursuant to the previous base year value transfer provisions do not count towards this 3 transfer maximum. So that's another important point. Next question. Now, moving on to questions about Prop 19 and the parent-child changes. So Prop 19 makes the previous parent-child exclusion operative for purchases or transfers that occur on or before February 15th of 2021. Since that was a state holiday, are purchases or transfers that occur on February 16th eligible for the previous parent-child exclusion? The answer, yes, except for transfers of property by inheritance. And again, this goes into reading Government Code sections 6706 and 6707, which provide that an act that is to be performed on a holiday may be performed with the same effect on the next business day, and that when the last day for filing any instrument with a state agency falls on a holiday, such act may be performed on the next business day with the same effect. Because subdivision C of section 2.1 describes an exclusion from change in ownership, the Board of Equalization is of the opinion that the date of purchase or transfer is the date of a change in ownership. Because the Government Code grants a 1-day extension for acts that are to be performed on a holiday, and February 15th was a holiday, transfers evidenced by recorded deed and transfers accomplished by an unrecorded deed may be accomplished on February 16th, 2021 and still be excluded. So that's going to create quite a bit of potentially some litigation, who knows. Next question. Prop 19 requires that a family home continue as a family home of the transferee. So the question is, must the family home continue as the family home of all of the transferees? The answer, no. Only one transferee needs to maintain the family home as his or her principal residence. So the legislative intent here was to limit property tax increases for family homes that continue to be used as a primary residence by their children, while eliminating tax loopholes that allow family homes to be used as rental property. Therefore, based on this intent, the Board of Equalization believes that more than one child may be the recipient of the family home, as long as one child maintains the family home as his or her principal residence. The family home may qualify for this exclusion. However, all the transferees must be eligible. Question 3, Prop 19 requires a family home continue as a family home of the transferee. By what date must the transferee establish the family home as his or her family home? The answer, the transferee must establish the family home as his or her family home within 1 year of the purchase or transfer. So again, the legislative intent is to limit property tax increases for family homes that continue to be used as a primary residence by their children, while eliminating the tax loopholes that allow for family homes to be used as rentals. Therefore, based on this intent, the Board of Equalization believes that the family home must be maintained as a family home by a transferee, whether the transferee that initially used the family home as a primary residence or another eligible transferee that received the property from the transferor. So in the event the family home is no longer used as a primary residence of the transferee, the property then receives a factored tax base year that applies had the family home not qualified for the exclusion at the time of the purchase or the transfer. This is because at the time the family home is no longer the primary residence of the transferee, and there's no transfer of the property, and therefore there can be no change in ownership on that date. Rather, at the time the family home is no longer the primary residence of the transferee, the change in ownership exclusion that applied at the initial transfer of the family home is lost. Therefore, the property is not reassessed, and instead it is taxed at a factored base year value that the property would have had the parent-child exclusion not been applied. Question 5. Prop 19 makes parent-child exclusions applicable to family farms. What familial relationship will establish the farm as a family farm? Answer, the family farm is a farm that is transferred between parents and children, or when applicable, between the grandparents and the grandchildren. There's no definition of family or any indication of the type of relationship that would make a farm a family home. A family farm. Rather, the operative provision is subdivision C1 of section 2.1, which makes clear that a family farm qualifies for exclusion if the family farm is transferred between parents and children. Therefore, the issue is not whether the farm is a family farm, but rather, is the farm transferred between parents and children? And if so, then the farm is a family farm. Prop 19 makes parent-child exclusion applicable to family farms. Must a family farm also be the principal residence of the transferee? Answer, no. The family farm does not need to be the principal residence of the transferee to qualify for the parent-child exclusion under Prop 19. The definition of family farm contains no requirement that it be the principal residence of the transferor or the transferee. Therefore, the only explicit requirements for qualification are that the family farm be used in a manner described in subdivision E2, and that the family farm be transferred between parents and children, and that the family farm continues to be used as a family farm by the transferee. And lastly, question number 7. Prop 19 requires a transferee of a family home to qualify for the homeowners or disabled veterans exemption. What is the proper forum for appeal for a transferee denied the homeowners or disabled veterans exemption? Answer. A transferee who has been denied a homeowners or disabled veterans exemption must file a claim for refund in the county in which the property is located, and if denied, must file an appeal to the Superior Court. So county boards of equalization have no jurisdiction to hear and decide an application involving any exemption matter except to determine the proper classification of the property. Therefore, an appeals board may not hear an appeal of a denial of the exemption. An appeal of a denial of the exemption must be filed in the Superior Court after the denial of a claim for refund with the county. So on that note, I am now going to pass it on to Ryan.
Thank you, Marie. All right, everybody. With that great background, let's move on to some examples. What I want to be able to provide you today is some clear, simple examples on how to calculate some of these factored base year value transfers, right? So first, we're going to look at the first component of Prop 19. And what Marie was talking about was if you're 55 or older, disabled, or victim of wildfire, you can transfer your factored base year value, let's just call it your property tax assessment, from your original primary residence into a replacement primary residence in any county in the state now. So what does that look like as far as an example and a calculation? And a lot of the examples I'm giving today can actually be found in that same authority that the Board of Equalization provided back in January. The letters, they call it letters to assessors, the ones they put out in January this year were actually pretty helpful, especially the one they put out in April. But let's take a look at this first example. So we have a husband and wife. They're that they originally purchased back a long time ago for $300,000. We're just going to say their factored base year value or their assessment, their original assessment's $300,000. And then they buy a new property for $550,000. So, I'm sorry, they sold the property for $550,000. So they made a good $250,000 of gain there, right? And they're going to go buy a replacement property for $500,000. Because the replacement property is less than what they sold their original property for, original residence, then there's going to be no increase in their property tax bill, right? So they could be able to take their original $300,000 tax assessment and transfer it over directly into the replacement primary residence. They see no impact on the property tax bill. That's a great thing for them. I think this is what people voted Prop 19 for. This is the result that the public wanted. Okay, so that's a very simple, clear example. Let's look at a different one. A little bit, slightly different facts. Same couple, originally bought the property for $300,000. They're going to sell it for $550,000, so the same fact so far. But instead of a new property that they bought for $550,000 or $500,000, they're going to buy one for $600,000, right? So this is like buying up. This couple's buying up. And because the $600,000 purchase price of their replacement residence is higher than what they sold their original primary residence for, that's the $550,000 number, that $50,000 difference is now going to be added to their original tax assessment. So we take the original tax assessment of $300,000 and we have to add the $50,000 to it. So now their new factored base year value on their new primary residence is going to be $550,000, which will trigger a slight increase in their property taxes. Basically, that $50,000 difference is what's going to be reassessed and add in addition to their property taxes. Not a huge hit, right? An assessment on $50,000 is not very much increase, but it is an increase nonetheless. So you can take this example and you can extrapolate it out to much more disparate numbers. Somebody with a very low, factor base year value of 300,000, but they buy something that's 1.5 million, that could be a much greater change in their property tax. So I think when we are looking at clients and they're asking us this question of what will this do to my property tax bill, we can at least use this formula to be able to calculate pretty close to what the increase in property taxes are going to be for these types of clients who are, again, 55 and older, and going to change to a different residence in a different part of the state. So that's the good part of Prop 19, as I call it. So let's talk about the bad part, probably what everybody's here to learn about anyways, right? Is, okay, what's all the hullabaloo about these parent-child transfers and the massive change that Prop 19 did? Well, there's actually a very simple formula. Marie touched upon this in the beginning, but I want to hit you up with it again. we are assuming in these facts, in these examples going forward, that we are satisfying those two prongs for Prop 19 for the parent-child component. The transfer is obviously, number one, going from parent to child, and the child is going to make the property their primary residence. So as long as we've satisfied those two conditions, then we can look to this valuation formula. How are they going to calculate what the limitation of a parent-child transfer is under Prop 19? So we take the parent's base year value, right? And we can add $1 million. Simple example, parents' factored base year value is $250,000. We can add $1 million to that. So we have a new $1.25 million exemption. And as long as the fair market value of the property at the time of transfer is below that number, then the child will not receive an increase in their property tax bill. They'll be able to basically inherit their parents' property tax bill. If the value of that property exceeds that high threshold at the time of transfer, then there would be an impact. I'm going to show you some examples of how this works. So let's start with this first simple example. And all these examples that I'm using for the parent-child come from this Letters to Assessor 2021/008. Board of Equalization, their website is actually really good when it comes to searching for authorities under there. You should be able to find these pretty easily if you want to go to the source directly. So here's the question that was posed. I moved back into the house I grew up in with my aging mother to help her. She needs care. Pretty common example as well. She wants to give me the house on my next birthday. So this obviously was before May of 2021 when this came out. So let's just assume that mom is going to transfer the home to her daughter on May 1st of 2021. So we're after Prop 19 is effective, right? So we're after that February 16th or 15th deadline. Mom's original base value in this property is $200,000. So she has a very low property tax bill, right? Obviously, we were looking for some tax savings. So when she transfers the house to the daughter, what is it going to do to the property tax change? Well, the answer is obviously it depends. It's largely going to depend on what is the fair market value of the house on the date of transfer, which under this example was May 1st of this year. If it's, again, less than that 1.2 million, so that's the 200,000 plus the $1 million we get to add to it, then there's going to be no change. No change to the property tax bill. The daughter will continue to pay that low property tax bill that mom has been paying for probably several years. But what if it's in excess of that? So let's just, at the bottom of this example, let's just use that number 1.5 million. So mom transfers the property to the daughter on May 1st. The assessor says, well, on May 1st of this year, that property was worth $1.5 million. We're not going to argue over the value under this example, but maybe there is some argument over that. But let's just say it is 1.5 million. Well, we have a total exemption level of 1.2 million, right? So we have a $300,000 difference. So that $300,000 difference is going to be added to the original base value of 200,000. So that means the daughter, upon receipt of the property on May 1st, and when this property is reassessed, she will have a new factored base year value, a new tax assessment of $500,000. The original $200,000 that mom had, plus the $300,000 difference in the value between 1.5 and 1.2 million. So the property tax bill under this scenario is going up 1.5 times, right? This is more than double of what the property tax bill is going to be. But there still is some savings here because even though she's paying property taxes based on the $500,000 valuation, it's much better than having to pay at 1.5 million, right? That's going to be a significant difference. So she's getting the full value of that $1 million exemption for the most part that Prop 19 does afford. Not the best case scenario because under Prop 58, the prior law, this would have been totally excluded. But under Prop 19, it's mitigated to some degree. It's not the worst case scenario, but it's also not the best. So let's move on to another example. What about partial interest? Pretty common, right? Families, I work with families, we have multiple children. We want to maybe give 25% to this child and, or maybe parents don't want to give 100% of the property. They just want to give a partial interest to the property. Maybe to thinking about the numbers and they're crunching the numbers and thinking, what is tenable right now? And they came up with this number. We're going to transfer 25% to a child. So we have mother transferring 25% of the home to the child. Maybe it's like in recognition that the child's been helping the mom, with some care, something like that, kind of similar to the earlier example. Well, we still run through the full analysis with the total numbers, right? So keep the 25% in the back of your mind as you run through this. We're going to come back to it. So if the taxable value of the mother's family home is $600,000, the fair market value is $800,000 when the 25% transfer is done. So remember that data transfer is going to be key for all of this. The fair market value of the $800,000 is less than the excluded amount of 1.6 because we get mom's original $600,000 assessed value plus the million, right? So that's where we're at 1.6. And because the fair market value is less, then the 25% interest is not increased and it's going to remain at 150,000. So this is when the 25% kind of comes back into play, right? We're going to take the $600,000 original assessed value. What's 25% of that? It's 150. That's going to be daughter's assessed value in her 25% interest in the home going forward, right? However, what if that fair market value of that home is in excess of the $1.6 million total exemption that we get? Let's say the fair market value is $2 million when the 25% is transferred. Okay, well, the $2 million is obviously greater than the 1.6 by $400,000. Therefore, we have to take 25% of that $400,000. So we're still getting the benefit of the exemption level, right? We're still getting benefit of that $1.6 million, that extra million that we get. It's the excess, that $400,000 excess that we have to take the 25% from. So that's $100,000. And that's going to be added to her $150,000 because that $150,000 is still 25% of the original $600,000 assessed value from mom. So now daughter is going to receive her 25% interest in the home with a new taxable value or assessed value of $250,000. That's the $100,000 plus the $150,000. So that represents her 25% interest. There is going to be an increase in property taxes as far as that 25% is concerned. And it's also going to change the whole new taxable value for the entire family home because that 100% of the 400,000 is being added on. We're going to add that on to the 600,000 that mom originally had. So that's where you see that number of 700,000. This is confusing with all these numbers being bandied about. That's why I wanted to put this verbatim in the slides. You're going to get a copy of the slides. Use this as a benchmark to kind of read through them in the future to think, okay, what was Ryan talking about when we have a partial interest? This is when it gets confusing. So look at this example and work through it, and you'll be able to see that it makes sense as far as we're just taking the same percentage of whatever that excess amount is going to be or whatever mom or dad's original assessed value is going to be. And we might have to add them up at certain points. But I do a lot of transfers of partial interest in properties. So not so much in the homes. I think that may rise if Prop 19 sticks around. And so that's why I think this example is one of the better ones I wanted to put forth to you. All right, so those were just some simple examples on how this stuff is calculated under Prop 19. So what can we do? What can we do to mitigate the impact that Prop 19 is going to have, especially on parent-child transfers? Well, one common and probably the most popular way right now is using legal entities, where we're going to move interest in legal entities, and the legal entities are going to hold the real estate interest, right, the real estate itself. Amongst children, we may run that through trust, we may run that through some other structures to maximize some valuation discounts, but it's going to implicate a whole different set of rules in Prop 19. And I'm going to go through examples on that. And there's a second option I just want to put forth is do nothing. What is the likelihood that Prop 19 in its current form sticks around? I'm going to talk a little bit about this, but there is a movement to change Prop 19 as to the parent-child part specifically. Because the parent-child change that happened under Prop 19 caught a lot of people off guard. In fact, there was quite a few people who were very angry. I got a lot of calls in January. I didn't know this was a part of Prop 19. Obviously, it was in there if you read it, but it wasn't in the commercials. Let's just say that. So let's talk about the legal entities part first. So I say limited liability companies or LLCs are the most common way to do this because there's just a lot of flexibility to use LLCs when you're talking about real estate, right? Corporations, holding real estate in corporations can be a tax problem. LLC is a lot more flexible, especially LLCs tax as a partnership. So there are different property tax rules when we're talking about entities. So legal entities encompass all types of legal entities. I'm going to use LLCs as my example. There's two specific rules in the legal entity world that we need to be worried about. And let me back up real quick. A lot of this comes from Revenue and Taxation Code section 61, 64. But I'll just tell you this. If you want to know about the legal entity rules, go to the Board of Equalization's website. There's a whole webpage they have dedicated to what they call the Legal Entity Ownership Program that has links to all these rules with examples. Because it can get a little confusing. It's a great resource. I just want you to know that. All right, so there's two rules we're going to look at. One is called the change in control. It's saying no member, shareholder, or partner can gain more than a 50% interest without triggering a change in control. So what that means is if somebody gains a more than 50% interest, they obviously have voting control over that entity. For property tax purposes, they will consider that a change in control in the entity itself, which will trigger a property tax reassessment because it's a change of ownership, which is the second one, change in ownership. When no more than 50% entity interests have transferred, we have no change in ownership. But once more than 50% of that entity ownerships have changed, they will consider that changing from like A to B. That's a change in ownership, and they want to reassess. So there's some specific strategies that can be employed using entities to avoid, like, go all the way up to where this rule is, but not cross that threshold, right? So it's not a complete answer. We're not transferring necessarily 100% of the property to the child or the children, but we are getting significant chunks to the child or children. So and they're very technical. That's the other thing I want to just bring up is using legal entities to transfer properties is one of the areas that I found that most of the county assessors' offices will look at pretty closely once they catch wind of it. They just want to make sure that somebody hasn't, triggered one of those two rules, because they would love to reassess, obviously. And actually, the change in control of an entity, if that occurred, will trigger a reassessment of all properties held by that entity. So it's a pretty severe hit if that's going to happen. So again, they're technical. Make sure you understand them before you embark on these types of transfers. I'm going to run you through a simple example of this. So mom and dad own some property. They want to transfer to their children, and they come to us and they say, we know what Prop 19 is. We understand that if we transfer this, and let's just say they have a vacation home and a rental property, right? We know we can't transfer those without triggering reassessment because they no longer qualify under Prop 19. So what can we do? Well, one thing we can do is, let's say mom and dad form an LLC, put the property that you want to transfer into that LLC. Mom and dad, you're going to be the initial members, the only members of that LLC, initially at least. And then you can gift or sell, but usually gift up to 50% of that LLC to the children. So now mom and dad are going to be 50% in the LLC. Children are 50% in the LLC. We have not triggered a property tax reassessment at all because we have not done more than 50%, right? There's no change in control, no change in ownership. Family may say, great, we're going to do that. And then we're going to dissolve the LLC. And so now mom and dad are 50% interest as a tenants in common with the children as the other 50%. And they say, great, so we've done 50% so far. Let's take this a step further. Now, as we go this next step, you start walking down the plank of risk tolerance, as I call it. So the family may say, let's do it again. Mom and dad form an LLC, put their 50% interest in the properties into this LLC, and then they gift 50% of the LLC to the children, right? So now mom and dad have 25% of the property, children have 75% of the property, and they dissolve. They kind of keep doing this until they can get that number that mom and dad have down to some real small number. You have to be aware of the step transaction doctrine if you're going to go through these extra steps. And I've had discussions with clients about this specific strategy, saying maybe if we go through the first step of forming the LLC, gifting 50% out, and just stop, we're good, usually. I mean, that's usually fine because that happens all the time. We're using gift tax exemption to exempt that transfer of the 50%. We haven't triggered the property tax rules. Nobody's really going to have a problem with that. But when we keep going forward and trying to get that portion that mom and dad own down to some small number, then there is a possibility that the assessor's office could invoke the step transaction doctrine, saying, I think we're mostly familiar with it, but maybe not. So what that doctrine really says is, they'll just look at what is the ultimate goal of all these transactions together. Obviously, the goal would be to avoid property tax reassessment in this situation. That's what the assessor would say. They say, because you broke it up in all these separate steps, the ultimate goal was to transfer more than 50% of that property to the children. Therefore, we're going to invoke the step transaction doctrine and basically take out all those steps and say, here's the crux of what you did. And therefore, we're going to be able to reassess. So it's a risk tolerance. It's all about having that discussion with the client and saying, this multi-step approach may be too far, a bridge too far, so to speak. Others are saying, nope, let's just go forward. So it's going to be up to every individual attorney and every client to be able to decide how far they want to take this legal entity strategy. A lot of the times I find with clients is they are very happy to at least get the 50% out, right, to the children. They made us all the LLCs, so then they go back in tenants in common with the hope that maybe Prop 19 gets changed in the future. And then we also have to, kind of balance this property tax question, which is what we're talking about today, with other tax law changes that are on the table, right? Gift and estate tax changes. So when you're looking at the whole estate plan or the whole, client's portfolio, and we say, what taxes are we really worried about? We're worried about estate tax, maybe some gift tax changes as far as that exemption is concerned, but then we have this property tax issue because of Prop 19, and it's a balancing act. And usually I had to find out that we have to run through several different tax analysis just to see, is this beneficial? Are we worried about the property taxes more? Are we worried about maybe losing the step up in tax basis or the estate tax more? And then how can we balance these two together? Which kind of leads me to do nothing. It's always an option. Why would we do nothing in this situation? Let's take a look at it. Well, there's no guarantee that Prop 19 is going to stick around. There is a movement to change at least the parent-child component to Prop 19. Remember, Prop 19 had those two components of, part one, the good part. If you're over 55, you can change between different counties in the state. But this parent-child change is the part that caught people off guard. And I think a lot of the voters were unsure about this parent-child part, at least how the impact was going to be. Now that we have seen what the impact can be, this movement says we need to change this back, at least maybe going back to what Prop 58, the prior law, was, where we can transfer a primary residence, no problem, and even up to $1 million of assessed value in other properties? Or will it fall into some sort of middle ground between Prop 19 and Prop 58? We're going to have to be attuned to what this new proposition is going to look like. It does, I've talked to people who are in this movement gathering signatures, and it looks like they've pretty much already got enough signatures to get a proposition onto the next electoral ballot. And so there will be a whole new proposition, definitely focused just on the parent-child transfers. And it's going to be a lesson from Prop 19 is to make sure we understand what's inside the proposition as far as what the change is going to be. And I expect it to be what more closely to what Prop 58 was, if not completely. But these things tend to change as we get closer to the election, so we'll find out. Again, we also have to look at, if we're going to do nothing, we still have to look at the balancing act of what happens with the estate and gift tax changes at the federal level, right? It's always a balance of estate and gift taxes. If we're worried about those things, if we have an estate that's high enough, we're going to be high enough with the new exemption levels, plus this property tax question. And so sometimes one tax is, more onerous than the other one. And we might want to plan more, let's say, for gift and estate tax and take the hit on the property tax, or maybe vice versa. So it really kind of depends on what the client's planning objective is. And we'll probably have to do some sort of tax analysis to see, which taxes are we really worried about the most, or which ones can we plan for the best? Planning for estate and gift tax can be tried and true, knock on wood, depending on what the change will be. This property tax one under Prop 19 is severely hamstrung us. Again, we can use the legal entities. It's not a total solution, but it is at least a partial solution. So takeaway from today is understanding what Prop 19 does, especially compared to what the prior law was. And that's why we had Marie go through what that prior law was, because that may come back, especially when it comes to parent-child exemptions. We will see. But, as what the calculations can look like, you can help be better advisors to plan for, if we're going to do some transfers, clients want to just say, hey, I just want to transfer my property to my kid. Okay, but let's look through the different tax aspects, especially the property tax hit. You can actually run the calculation and say, here's what the property tax, change would be. And I think that'll just help everybody involved to make an informed decision. So Marie and I want to thank you for joining us today. And we hope you learned a little bit more about Prop 19.
Great. Thank you so much, Ryan. If I can just have you stop your share screen. Great. Thank you. All right. Well, everybody, my name is Teresa Hurley. I am the Executive Director of the Contra Costa County Bar Association, and I would just like to give a huge thank you to both Ryan and Marie for this very long and winding road that we seem to be going on with the different propositions relating to property transfers. As somebody who is one of 5 siblings and parents who bought a house in Mill Valley in 1968, it's been a discussion that we've actually started having as well. So thank you. This was very informative. I'd also like to say thank you to the real estate, tax, and East County sections for helping us put this program together. So stay tuned. After this, we're going to have a live Q&A session with our panelists after just a few quick announcements. First is that the materials and evaluation forms for this program can be downloaded from the session page. There's a files tab that's just above the chat where you can get all that information. Attendance certificates are going to be available after the Thanksgiving holiday. If you're a CCCBA member, your attendance certificate will be in your membership profile. If you're a non-member, please check out our FAQs tab for more information on how to access your attendance certificates. And again, if you have any technical difficulties, check out the FAQ tab. So now, please click on the link below to join the live Q&A session with Marie Quashnock and Ryan Lockhart. I'll see you there.